if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is the reverse of what you're saying.
No, I'm coming to that.
Keep
I'm
it-
coming
keep
to
it
that.
in mind.
No, I have it in mind. I have it in mind. And when I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action
It's
was.
a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In India, my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the president, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
With the constitution, these references, when they say subject to approval of the president, is it unilateral discretion of the president, or it is president advised by the chief executive, albeit the prime minister, whoever that is?
My lord, if you look at the jurisdictions where we have this position, of course, in India, he acts on the advice. And if, for example, under Article 191,
government has the last say, not parliament.
Yes, it was no, my lord.
There's a distinction. Prior approval of the president means effectively prior approval of the prime minister, not the legislature.
Yes.
Okay.
You said that in the Indian constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that when I take you to Article 191. I'll come to that. I'll come to that when I take you to 191.
I'm just clarifying जो आपने argument.
My lord.
वहाँ ये नहीं लिखा.
जी, when I'll address subject to law, I'll be addressing.
Page 7 पे you reproduce.
Page 6 and 7, yes, my lord. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest development, or later development, is the Constitution Reform Act of 2005 of the United Kingdom. Now, under Section 45 of that act, the President of the US Supreme Court makes the rules, but is required to consult with the Lord Chancellor and all the bar councils while making the rules of procedure. So this is the progression, or this is how this is the system that we have in place.
2000 UK Act, does that
2005.
2005 UK Act, for example, do the rules have to be placed before the Houses of Parliament, or is there any involvement at all by the legislative branch?
There is none, but
he has to consult.
He has to consult. Now, whether
other than the Lord Chancellor, who is a dying breed sadly in the UK system, but anyway, Parliament has made the law despite their rule of sovereign legislative supremacy. The Parliament itself has said it's got to be totally independent of us.
Yes. Yes. And for that, now I take your lordship to Article 191. Now, this is where I will address what the term law means and what is the scope that this term has, and whether an act of Parliament would be actually covered under the term law or not, or whether we can give it a meaning where an act of Parliament would be excluded from the definition of law and everything else would come under the.
Why? I don't even understand this debate. Why is this? What is I couldn't understand the point of counsel. What was he saying really?
My lord, the counsel was arguing, began by referring to clause 1 of Article 8, where it said that any law or custom or using having force of law, etc., shall not be made. And then clause 2 said that places a limitation, embargo on the state to not make any law which is inconsistent with the provisions of this. With the chapter.
This differentiation between an act of Parliament and law, what is the significance here?
My lord,
I mean,
in my
I missed the
respectful
point. I
submission, there is
tried
none.
to,
In my respectful submission, there would be none as far as Article
but
191
you
is
were
concerned.
started by arguing on maintainability. Let's finish your argument. You're now addressing his arguments.
Gee, now what I'm on insofar as maintainability is concerned, my lord, my submissions are that this law actually addresses the public concern. It addresses the issue of public importance by bringing in transparency and by structuring the discretion and by democratizing this institution by and transparency by conferring powers or by, let's say, devolving powers.
Mr. Attorney General, so both sides agree that a question of public importance is addressed in this. The only question is now whether a fundamental right has been violated,
Yes.
and if a fundamental right has been violated, which fundamental right?
Correct.
Because question of है इसमें आप उसको मुख्तलिफ तरीके से पॉइंट कर रहे हैं आप कह रहे हैं जी पब्लिक इम्पोर्टेंस क्वेश्चन है जिसमें हमने एड्रेस की the other side doesn't agree but the common denominator is there is a question of public importance.
I think my lord is correct. To that extent, you are in agreement. Now, the other limb of the argument, I mean, public importance is in my opinion, a variable. Uh, the other importance is enforcement of fundamental rights. And other than that, I think the general, how the law is developed, a law is sustainable unless otherwise proved. So the burden is on the person who challenges a law to say what has been done. If he's invoked Article 199, his jurisdiction is far wider of the high courts. You can attack income tax law, any other law in Pakistan for whatever reason you can, not limited to enforcement of fundamental rights. Attack under 184.3, leaving aside the public importance, and I think you both are probably agreement there, is a narrower attack. So the person has to come within attack on a fundamental right. What is the fundamental right that has been violated? Your arguments, what I could understand from is, rather than violating a fundamental right, this is a beneficial legislation for the litigant, not for me, not for the state. Everyone may benefit by it or none may benefit by it, but there's certainly, you're not taking away anything, that you are stopping a right of appeal, you're giving a right of appeal. Whether that can be done, that's another argument, constitutional plane. Whether that could be addressed in 184.3 or under 199, it's an argument. I'm seeing myself sitting in original. Otherwise, every case will just be filed in the Supreme Court. Don't bother about the high courts at all. If you read the jurisdiction of 184, can we just read it for my own benefit, because we tend to forget certain words of 184.3. We don't have additional powers, we have lesser powers in the high courts.
Clause 3, my lord.
पूरा पढ़ें.
जी.
One तो government वाला है ना.
Should I read 1 and 2 as well?
Yeah,
3 पढ़ दूं.
3 पढ़.
3 पढ़ दूं. Without prejudice to the provisions of Article 199, the Supreme Court shall, if it considers that a question of public importance with reference to the enforcement of any of the fundamental rights conferred by Chapter 1 of Part 2 is involved, have the power to make an order of the nature mentioned in the said article.
In other words, which is the said article? 199. So the High Court, you don't have to go for a public importance matter. You don't have to go for enforcement of fundamental rights. You can still go to the High Court. Here, we don't have extra powers. We have the same powers as the High Court, but we have two restrictions: public importance and enforcement of fundamental rights. Public importance is variable. Let's stick to fundamental rights. So the power here is not much larger power. My reading of the Constitution, much narrower power than the High Court. High Court may strike down this law, arguably. and then we can sit in 184 as an appeal. Then we have more powers. I don't know, am I wrong in my understanding?
That's correct, my lord. And my lord, as far as challenge to the vires of this law.
Just to add to that, where a law deals with parts of this court, the Supreme Court of Pakistan, do you think it would be appropriate for the High Court to adjudicate upon it?
My lord, in another proceedings, this is a submission that I had made in other judgment, where a specific question was raised, and my submission, respectful submission at that time was that yes, and I maintain that
But
position.
are you aware there is a judgment of this court which says otherwise?
My lord, now I'm before a full court, so I'd just, based on that, I'd just proceed.
आगे बढ़ते हैं.
My lord,
I know you press for time. जी.
Attorney General, can you explain the word enforcement? It's not the infringement of the fundamental right. It's the enforcement of the fundamental right. So
Public
if the law-
importance with reference to the enforcement, with reference to the enforcement.
Here, fundamental, public importance, fine, both parties are there. Now, had it been infringement, then you were right, that there has to be a right which was infringed. Here, it's more wider, it's enforcement. So they are saying that this is a matter which relates to access to justice. So it's an enforcement of that particular right that they're talking about. They're not saying that it's an infringement of the fundamental right. Can you explain, can you expound on that?
my lord. Now, of course, as I said, my lord, I reiterate that yes, access to justice is a right recognized by this court covered under Article 9, and to that extent, yes, it would be a fundamental right. Now, what they had to show was, the burden is on them, while challenging the constitutionality of this act on the basis of lack of enforcement of fundamental right, as my lord has just pointed out, not infringement of right. What they have to show is that this law does not, in fact, enforce this right of access to justice.
No. It's first we are at the threshold of the maintainability. We don't go into whether this law is right, whether it is wrong, whether it is enforcement of the fundamental right or it is an infringement. As far as maintainability is concerned, public importance is done. Then we come to this issue of, does the petition that they have filed, does the petition talk about enforcement of the fundamental right or not?
The petitioner, my lord, proceeds on the basis that by way of this act, powers conferred upon the Chief Justice under the Supreme Court rules have been curtailed or taken away, and that then results in this law being unconstitutional. It is not the case here that this act in any way prevents enforcement of any right.
Attorney General, one way of looking at it is the enforcement part, that whatever act has been challenged impedes the actualization of the fundamental rights. So perhaps it's interchangeably talking about infringement, however uses a different word. So if a citizen comes and says this particular act thwarts or impairs the actualization of my fundamental right, I'm coming to the court. So enforcement or infringement might be synonymous. One more thing, I think the question of public importance also is a threshold entry point. Suppose if we see, don't you think the petitioner will have to show that in order for it to be a question of public importance, there must be apparently that law must be against public interest. But suppose if it's clearly in favor of public interest, does it constitute a question of public interest? To become a question of public interest, it must apparently prima facie be something against public interest, and then you say, yes, it's a question. But if it's so obvious that the whole law is in public interest, for example, do you think there's a threshold to that effect, or there isn't any?
My first part of my submission, my lord, was that the question of public importance, my lord, when I pointed out that what this law does is it democratizes this institution, brings more transparency, structures the discretion, it actually advances that public interest. And therefore, they fail on that threshold, that count as well. Where
Attorney General,
my lord.
on my repeated questions, in response to my repeated questions, they conceded very explicitly that this is a good law. It enhances access to justice, and also, speaking for myself, it addresses a very, very big issue of internal and institutional independence. Now, in that context, when this is an admitted fact, the only question whether the parliament had the competence or not, क्या जो 184(3) की requirements है वो fulfill होती है, because there is no enforcement of fundamental rights.
My lord, if that is so, then these petitions have to be rejected on this basis alone, because insofar as legislative competence is concerned, 184(3) cannot be pressed into service.
So
No,
taking,
but, if we'll let you, I think a lot of questions are coming up. We'll note. I'll try to make a point.
These are, my lord, please.
Well, अगर आप थोड़ा सा अपना continue रखें, I want to know where you're going. Okay.
Attorney General, if I may ask you a question, is it in the public interest that Parliament, or for that matter, a provincial assembly, remains within the limitations that may be placed by the Constitution on Parliament or a provincial assembly? Is it in the public interest?
My lord, which fundamental right would it
I'm not
be
talking of
affected?
fundamental right. I'm talking of public interest.
Of course.
Of course.
Yes.
So therefore, if a law,
Again, this is happening, which I must, sorry, interject. I would, with you have agreed with now here, I won't agree with you. I will say it may be unconstitutional, but not within the parameters of 184(3). There may be a lot of unconstitutional things going on in Pakistan, but it won't come within the parameters of 184(3). That is the fundamental point. That's my way of approaching it. Others have different ways of approaching it. So I think आप जरा चलें, फिर आप note कर लें सवाल.
I just, this part I
Attorney
just
General,
conclude.
if I may continue, sorry, if I may continue. It is in the public interest. I'm not speaking of any fundamental right. I'm only speaking of public interest. It is in the public interest you accept, and I think rightly so, that because we have a federal structure, Parliament and provincial assemblies must remain within constitutional limits, right? Whatever those constitutional limits are. So therefore, it seems to me to follow logically that if Parliament makes a law that is ultra vires, or a provincial assembly makes a law that is ultra vires, it is in the public interest to challenge that law. Because if remaining within the constitutional limits is in the public interest, then going beyond those limits and making an ultra vires law is surely a breach of public interest. What would you say to that?
That touches upon the legislative competence.
No, I'm talking of public interest.
Yes, but,
Yes,
no, but
is it
any
in the-
law, a law
is
cannot
it
be
in the
struck
public
down on the
interest?
basis of just
Where,
being public.
where the challenge can be is a separate.
My lord, let's just take a step back. Any law made by any legislature, provincial assemblies or the parliament, would be a matter of public interest and importance. It is a law which is being enacted. Now, in order to examine that law, in order to assume jurisdiction to examine that law, we have to look at, in the case of Supreme Court, Article 184, and the cases of High Court in 199.
नहीं, आप
Now,
देखिए, आप तो कह रहे हैं ना, मैंने जो नोट किया, हो सकता है मैंने फिर गलत नोट किया हो, आप तो कह रहे हैं कि this challenge fails on both counts.
yes,
Public interest and this.
जी,
तो मैं अभी सिर्फ public interest पे देख रहा हूँ ना.
but
तो मैं आपसे पूछ रहा हूँ, I mean, speaking for myself, it seems to me that any law which is ultra vires, whether by parliament, whether by provincial assembly, meaning breaches the limitations, whatever they may be, imposed by the constitution, because the constitution is supreme. It is contrary to public interest. Has to be.
now, let me just quickly address this, because this is a maintainability issue here, and I want to address that issue here first and foremost. The two conditions provided under Clause 3 or required under Clause 3 are connected. It has to be a matter of public importance with reference to enforcement of fundamental rights. Now, independently, any legislation, any statute, any rule or any regulation would be a matter of public importance or public interest for that matter. Now, in order for this court to assume jurisdiction, now this court does not assume jurisdiction under 184(3) on a legislature, on any law being enacted for want of legislative competence. It has to be ultra vires or violative of the rights, fundamental rights granted.
So you say that the word relating to enforcement.
with reference to the
that
enforcement
is,
of.
that you say is the buckle that connects the two things.
That is the buckle that connects the two, and that is where it actually prevents, if I may say so, this court to examine constitutionality of a statute on legislative competence.
Is legislative competence not in the public interest?
As I said, Your Ladyship, this is something, legislative competence alone is something which can only be examined in one night.
Is it not a right that everyone has under the constitution
My lord,
that laws are
legislative-
made in a particular
The
way?
legislative competence, of course, as we understand, as I understand it, what you have to see in the act of, when is an act of parliament, whether Article 70 read with the list permitted it or not, or whether there is a provision of the constitution which directly confers that power upon the parliament, whether that provision permits it or not. And if those provisions do not permit that legislature to legislate on that particular matter, then yes, this is a legislative competence issue and it is not permissible under 184(3).
So in your opinion, the law is good law, parliament is competent to make the law, and every provision of the law is valid and does not in any way violate any provision of the constitution. So then what happens again? I go back to the full court hearing aid, and you are given a right of appeal under that. So are they not then entitled to their right of appeal in the event that the court decides that these petitions are not maintainable? They cannot challenge it. And does that not go to the fact that once again you've put the burden on the court itself to decide when it wants to constitute a full court and block that right of appeal, and when it wants to constitute a smaller bench and allow that right of appeal?
And whether the act is in field or is suspended.
I
unfortunately
think my
still
illustrious colleague has raised a very valid point, and I was thinking about it during the break. And if we read the right of appeal, it first of all it talks about an aggrieved person. I'm trying to envisage a scenario where one would be aggrieved. First scenario. Second thing is we can, and this is permissible, read down legislation. We can, for instance, read into it that wherever there is a full court, needless to say, you cannot have a right of appeal over the full court, so that one can read down the legislation that those cases. But which right have we determined? What have we taken away from someone? Someone gets an extra right to challenge a judgment, if at all it's an irritation to us. Oh, now you have to have the appeal. Oh, now the review jurisdiction has been extended. So what are we doing? And it's not conferring this power to an executive functionary, to the legislature, to the president, or to anybody else. It may be nuisance value for us. Our reviews are going, our appeals are going, that sort of thing. What are we taking away? If the judgment is correct and in order, should we shy away from looking at it because someone files an appeal? Yes, it may bring in litigation into the court. That's the downside, may be said. But where is the aggrieved person? Who will be the aggrieved person be? The person affected. Because I think the 184.3, the whole intendment of that was for not for lawyers. It was not for the well-to-do. It was not for the multinationals. It was for the poor, the dejected of society. We have a whole chapter on the principles of policy, which no one bothers to, we don't read. Bonded laborers, transgender, women rights, children, they can't come to court. We can intervene, 184.3 can come to the rescue. So I was looking at things in that perspective. We have to see the whole entire constitution as a whole. We just stuck with one provision that somebody says, hey, please tell me how you aggrieved. I kept asking him, are you aggrieved? He says, no. They couldn't do it, you can do it. That's about the argument that I've understood so far. That's a valid argument on its own. Yes, to be addressed, for instance, the income tax ordinance has certain provisions that have been challenged before the High Court. Could we entertain it on 184.3? After all, it is legislation. After all, it's a public interest. After all, it's a taxation matter. It will meet all the tests of public interest. But it is not, because taxation is not a fundamental right. You can't tax or not tax or whatever. Nobody can say my right not to be taxed has been infringed. So go through the High Court route, get a 191 petition, come to the Supreme Court in 184. That is appellate jurisdiction. So we should read the Constitution and not just pick the words, we are just stuck with these words, two words also. Who's harmed by this? The only thing is you've taken away our power, you've taken away specifically the power of the Chief Justice. That's one irritant. You've given a right. That's another irritant. You have created another same lawyer. Okay, person wants to waste money on another lawyer, do so. So his pocket will be lighter. What is it to us? आगे बढ़े थोड़ा सा.
Mr. Attorney General, if I may, sorry, here, take you back to what you were saying about, and I understand your point relating to the buckle part of it. So here we have a law which relates to the practice and procedure of the court. And that is, you say, you accept that any law which is ultra vires is against the public interest, but you say the buckle is missing because it doesn't, it has to, it's not just legislative competence alone, but it has to relate to fundamental rights. So I was just
If I
wondering.
may rephrase it before my lord formulates the question. Legislative competence cannot be interfered with here.
No, I'm just saying, I understand that. So he may care on, yes. But breach of legislative competence contrary to the public interest. As until it is related to fundamental right, 184(3) cannot be invoked. Yahi aapki argument. So I was just wondering that the subject matter of this law essentially is the practice and procedure of the Supreme Court. Article 10A relates to due process. So surely any law relating to the practice and procedure of any court, but let's take the Supreme Court, which is ultra vires, surely that affects due process and therefore is directly relatable to a fundamental right. What would you say to that?
And that is where, when passing this threshold, of course, when a petition comes before your lordship, so before this court under 184(3), these are the two things which are to be examined at first instance. Now, once this threshold is met, then, and the burden is just discharged.
You Article 10A. It helps sometimes to refresh our memories.
For the determination of his civil rights.
Of his civil right, not the Supreme Court civil rights. आगे पढ़ें.
And obligations, or in any criminal charge against him, a person shall be entitled to a fair trial and due process.
It's nothing to do with the Supreme Court's due process. It's his. Have your right of appeal been taken away? Your right of cross-examination been taken away? Have your right of a statement under 340 been taken away?
So that's where then it takes me, my lord,
Surely,
and
Mr.
I just
Mr.
addressing your
Mr.
question.
Attorney General, the subject matter is legislative competence in relation to practice and procedure. Surely, as a matter of principle, it's not a question of whether the law is taking away. It is this due process in and of itself? And if the law is ultra vires, the answer is precisely because it is ultra vires, it can't be due process.
So let's proceeding on this.
Whatever it says, whether it says
I'll go with it.
Chief Justice is masters of the roster or 5.
When somebody brings in, and let's assume, for the sake of argument, let's assume, and for a moment, if it is assumed that yes, it is a matter with reference to fundamental rights as well, then what has to be shown in the first instance is that this legislation fails to enforce or infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
They have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue, but I think we have our own views or opinions. आप चलें आगे.
Now,
you have to persuade us, not we have to persuade you.
Just one question, I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been dismissed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law would that law stand?
देखिए, I would rather consider these.
Competence की बात कर रहा हूँ.
नहीं, yeah, let's consider what this law did. Maybe tomorrow that very matter
Yes,
comes before us.
So the question is.
A second
the
appeal.
question
My
is-
lord's
no,
question
no,
is a second
no,
appeal would
no,
be
not
provided.
at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, can be provided by ordinary legislation? The example I gave you was an extreme example.
Right,
I mean, the first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any
और
provision
वो
in the
उसमें
constitution
उसको
preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो इनलार्ज किया, पहले एक अपील थी, अब हमने दूसरी कर दी है, तो इसलिए ये हमारी कॉम्पिटेंस में है. Would that argument stand?
Noted, my lord.
ये
आप बाद में जवाब दे दें, आगे बढ़ते
ऐड
हैं.
कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the constitution preventing the parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General,
Hello.
please, you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically, and Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can
does-
be
It does not.
proceeded
Three,
under
yes.
Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
And how that can be moved before the Supreme High Court under Article 199 of the Constitution.
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act 2023 Act is covered under the definition of law, howsoever expansive definition, however expansively the term law is defined. My lord, Article 260 has two definitions. One is of an act of parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines the federal law. It says,
You say over here, law includes statute law.
yes,
Point.
yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
It's to be covered, then why didn't the Constitution say by an act of Parliament? Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles. And so you have to, the interpretation has to be given to the word law and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say just by an act of Parliament, it would have used those words.
Your Ladyship, when we look at the provisions from where the Parliament draws its
Why did you look at
legislative
75.3?
G 75(3) and 141 and 142 as well.
वो पढ़ लेते हैं जरा, उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the president has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura. So
Law
it
is what happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says the state shall not make any law. Now, the state is not just the parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any taxes.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. You don't say federal law. It says
It does not. What I'm saying is,
I have a question for you. Suppose a provincial assembly under Article 191 law बना सकती है.
oh, 2000 के अंदर 2000 Supreme Court deals with that question. Yes, they cannot. The answer, because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175 for that matter.
I draw your attention to entry 58.
Relates to the federation also. Yes.
Kindly read it.
Matters which under the constitution are within the legislative competence of parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on Parliament to make statute law, and in terms of Article 191, is relatable to entry 58. Entry 55 has got nothing to do with Article 191. And this connection, first of all, excludes the example that I gave of a provincial assembly making a law over here, right? And secondly, it establishes that here there is a direct grant by the Constitution, by a specific article of the Constitution on Parliament, as opposed to the general grant as conferred by Articles 141, 142, and so on. That's a general. This is a specific grant. Because precisely it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that entry 51 has no relevance for present issue.
Entry
55 has no relevance. This is a matter between, and insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lord may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law, so you can
Yes.
read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution,
सुप्रीम कोर्ट प्रैक्टिस एंड प्रोसीजर एक्ट 2023 के
55, sorry, 55.
55, yes,
Jurisdiction
it is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Should
sorry,
be read
item
Why is
58.
it not coming under 55? It says
It does.
enlargement of the jurisdiction of
It
the
does.
Supreme
That's what
Court
I said.
and the conferring up thereon of supplemental powers. So it
What I
has given
submitted,
us
sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recodic judgment. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted.
It's
Section
authorized.
5 is covered under entry
So
55.
you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
Now, you are not, please don't take questions. You just hear them, write them
My lord,
down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Senate Attorney General.
जब आप देखिए हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं, पॉइंट्स ले हम नोट करेंगे, हम आपको सुनने के लिए बैठे हैं, आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको।
Now I just quickly rush through my submissions and
one question that in order 11, the use of the word law, the term law, you think it carries the same meaning as in Article 191?
yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been.
Or you can call it a sharing of the burden.
Sharing of the burden.
It's a huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as section. Absolutely. And because what it does is,
I don't trust them. That's the only other way.
It is in this time when we want the justice system to be more efficient. It actually helps when there are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before your lordships under 184.3. It's actually the appellate jurisdiction of this court, which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency goes down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero. But this is what is being sought to be assessed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various judgments was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution, you do a 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law? Of course. No. You see, you are saying this is a law
If
affecting
it
the
repeals it, yes.
is that this is a law affecting having such a salutary effect. It is having this, that, and the other. So someone can say, "जी parliament का तो power ही नहीं है, ये law को repeal कर दें." या फर्ज करें अगली parliament आती है वो section 2 को फारिग कर देती है, वो कहती है जी chief justice का power है वो, that's good enough.
My lord,
सकती है. आपसे पूछ रहा हूँ.
जी जी.
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा. मैं कंजेक्चर्स पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा. ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे. मैं ओपिनियंस कभी नहीं दूंगा. आप हमारी या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे. आपका काम है अपनी सरकार अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म. हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा. भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे. बहुत सारी चीजें आप फोकस कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत. हम लोग बैठ के इधर एक कंडीशन का फंड में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है. मेरी तो मुझे तकलीफ हो रही है. सुबह से 57,600 कोई 57,000 है. अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़. आप चला लें एक महीना केस, हमें क्या फर्क पड़ता है. फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म. ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे. आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है. मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है. ठीक है, वो एक अलग बात है, आइन कानून पर स्टे चल रहा है. फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें इस कानून को, ये तर्क कर दें. मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे. कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है. हमें आपको परसुएट करने की कोई जरूरत नहीं. आप हमें परसुएट कर लीजिए, और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला.
My lord, my learned friend is recording the question.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल.
So therefore, my question stands. Tomorrow, if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
if
Attorney
it so
General.
happens,
Question.
Yes,
This is
Learned
not
Attorney
conjecture.
General.
This is
Yes,
to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
absolutely,
General.
my lord.
Absolutely.
Learned
it is
Attorney
in Parliament's competence. And if I may say
I'm
so, my
sorry,
lord,
you
My lord,
you
I have-
provided assistance.
I have,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely.
Yes.
Yes.
Mr. AG, to your right.
Ji.
Section 2, it's provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still, this power has not been given in the act. Again, there will
My
be.
lord, the committee is to determine its procedure, and then it, with regards how the meetings are to be, this committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta registry for 1 month, for 6 or for 1 year. Is it possible?
My lord,
What would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how where and how the meetings were to be held, and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so, with regret, was the first. My lord, this is exactly what under subsection 2 the committee is to do as the first
We will regulate through rules. They will regulate this act through rules.
My Lord,
Ji,
the committee will determine its procedure the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is an SRO or as a rule or whatever they call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my Lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and it was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to examine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who would then first determine whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring
But
judgment.
This doesn't answer the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is, there's a distinction between what is filed under 184 and the suo motu, and that's why.
My question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further if providing guarantees. And my only question is, are we not accountable to the litigants?
Absolutely.
The Parliament is the representative of the litigants. If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative. And we are there to serve the litigants.
And if I may, my lord.
Normally, you see the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it himself. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks it. Judicial power is not in any way impeded because judicial power comes after the bench.
Section 3 talks about invoking of jurisdiction, and that is what I was addressing.
Specifically states that the committee would examine. The word used is
and that's what I was addressing.
For examination, if the committee is of the view that the question of public,
this is exactly
so it's a judicial power.
Yes. So
how can the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold कि ये जो overlap हो गया है कि administrative function और judicial function को control कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice used to do. They will first examine it and then constitute a bench. और यही वो tension थी जो आप paragraph 53
Please take one question from this side, AG sir.
Oh, sorry.
The Article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship says, is the Chief Justice and the judges of the Supreme Court.
184 I'm
जी
talking
जी,
about.
तो 184 में जो सुप्रीम कोर्ट है, सुप्रीम कोर्ट को डेफिनेशन जो है वो 176 से फ्लो करेगी।
जी जी.
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द
All the judges.
No single person is the
Yes.
Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं, ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that
by committee that could be
Mr.
an
Attorney
fair
General,
outcome.
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that could be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with under Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
in what, and in continuation, and what remedy would be available to him? Because this is an administrative order, it cannot be challenged in appeal, except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. It is just to look at the
My lord,
file
ये जो
and-
threshold है administrative
Nobody's talking
side
about a
पे day
hearing
in day
here.
out basis पे हमें cross करना पड़ता है litigants on this side.
I'll
यहाँ पे objection आ जाते हैं registrar के
नहीं,
कि ये meet नहीं
I'll
करता.
tell you what's been happening. Number of 184(3) petitions have come up that the office has put objections.
Yes.
Not the judge, the office.
Registrar, yes.
जी, one very low.
बिल्कुल.
ठीक है, उन्होंने objection लगा दी, not does not come within a
उसके chamber appeal में जाना
ठीक
पड़ता
है. They've come to me some of the absolutely ridiculous kind of petitions. ठीक है, they're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office says not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ की अपील है? कुछ भी नहीं है. End of story. ठीक है, तो यहाँ तो बल्कि वो भी जुरिडिक्शन बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पार हमें दे दिए हैं, उसके पास होना चाहिए, असिस्टेंट रजिस्ट्रार के पास तो रहने दें उसके पास, वो बेशक बेहतर तयन कर लेगा, जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का, राइट आपके सारे महफूज हैं जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटीशन डिसमिस कर दी तो 199 में आप नहीं जा सकते हैं या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज. यहाँ तो लोग अजीब अजीब चीजें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, उसको डिसमिस कर दिया, इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. आई डोंट नो what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटीशन आती है, जब कोई पिटीशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेक. So that is one route. The 184(3) का दूसरा है suo moto. Now, this provision, in fact, cures the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most, Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee where the appeal lies.
Which is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता दें अगर 2 जजेस या 3 जजेस बेंच चल रहा है जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर समझते हैं कि दिस इज केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और जस्टिस इनकार कर जाता है कि तीनों से एग्री नहीं करता. He has all the power, more power than 3 judges sitting in the court. The Chief Justice alone, sitting in a chamber, can undo this.
And the suo motu particularly, उसमें तो और ज्यादा फिर problematic है, because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or wherever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide a appeal against
My lords
that
can
order.
suitably amend the rules
You
and
see,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती, आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43
I think
years.
this act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all these years.
You were too polite to say that.
My lord, we have section 4.
Read that. Actually.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी तो उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amended
Mr. Attorney General, entry 55 says that we'll confer, enhance your jurisdiction through एक और 84 की appeal बना दी है. तो enhance
185 की भी फिर एक और अपील बन सकती है.
बन सकती है. सेकंड अपील तो है, हमें वैसे भी बताया हुआ है हमने कि
Speaking for myself, Learned Attorney General, speaking for myself.
Why not then a third appeal or a fourth appeal or a fifth appeal?
Obviously, it's the parliament. Parliament won't do absurd things, and of course,
it's not a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
Surely does.
Exception. No, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
नहीं, infinity नहीं है. Obviously, we're talking about the parliament here. We're not talking about.
आप बात फिर आ जाती है conjecture और theory और ये और वो बात principle की हो रही है. असूल समझने की है ना. एक दफा एक बार को concede कर दिया जाए, accept कर लिया जाए. In principle, then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
Lord,
this is the
great
point.
Respect.
Again, a review jurisdiction भी है ना. अब review jurisdiction का क्या concept है कि Supreme Court में finality हो गई. अब आप maximum में review कर रहे हैं.
With great respect, when it comes to even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can you go to the next point?
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here, the appeal has been provided in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And,
so I don't see how.
and in a context where this court becomes the first and the final court in the same proceedings.
That's
Where-
done. Are you done?
My lord, to this extent, and I'm just going to conclude my other two submissions here. I have placed on with my
We'll
paper
certainly
book the
look at
judgments
it,
of
don't worry.
in Baz Mohammed Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my lord. My lord, section 6 now, right to.
There was one concern also expressed by Justice Aisha Malik, which was that if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे angle देखे होंगे, या आप कैसे address करना चाहते हैं?
उसमें एक ये बात है, मैंने अपने written submissions में ये कहा है कि आप इसको to that extent read down कर लेंगे.
इस हद तक read down करें.
जहाँ पे full court होगी, naturally appeal
आप 4 और 5 को harmonize अगर कर
but
लें,
आप उसको ये कर सकते हैं, sorry sir. Just
I'm just saying, if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
My lord,
That's
ये अब
quite
15
simple.
बैठे हुए हैं, so मैं just will say, so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 member बेंच बन जाता है. फुल कोर्ट तो नहीं है.
My lord would be mindful of this.
अब ये हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं.
My lord,
आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया. आप ये
what I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर.
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट. तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग और राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए?
8 member बेंच बन जाए, 9 member बेंच
So-
बन जाए, राइट ऑफ अपील खत्म हो गया.
So let me just
I think what we can do is
writing, my lord.
we can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
एक्चुअली जब वो सीएमएस थी फुल कोर्ट के लिए जब आर्ग्यू हो रही थी, उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए. आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए. आपको तो कहना चाहिए दिस मैटर शुड बी हर्ड बाय लेसर नंबर. वो सीएमएस क्योंकि वो हेयरिंग पे नहीं गई, बट
But the burden
And
at the end of the day was
question
on us.
question was in fact put by me.
My lord,
And so therefore, it's not that the question was not there. It
my
was-
lord, if I
I
may
mean,
briefly
just-
respond to it, followed by a
only eight people were on
response in
that bench
writing.
at that
let,
time.
let, let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डर शीट पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पोजीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं। अगर हम बेंच पे एतराज करें इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते हैं, व्हाई नॉट फुल कोर्ट?
So मैं इसका brief एक response दूं and then it followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench,
मिस्टर अटॉर्नी जनरल, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
in cases,
प्लीज
in circumstances में ये हो सकता है, जैसे अभी भी है।
रिपरकशंस तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से।
So let me put it differently.
ये
Now
फुल कोर्ट कभी बैठ ही नहीं सकती।
नहीं, full court आप बैठेंगे
Article
in
184
exceptional matters,
questions, which are the most important question that can ever be raised before the court.
in exceptional circumstances, it
General,
might be so.
Mr.
But
Attorney
does that,
General,
is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or at any large bench, then that be so. I mean, that is how the committee will decide looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled.
Can
My
be
lord,
read
section
down.
6, right to appoint.
Section 5 can be read down.
My lord, to that extent, my lords can hold that in exceptional cases and when a situation this sort arises, that be so.
राइट ऑफ अपील पे सब्सटैंटिव राइट नहीं है जो स्टैट्यूट।
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184(3). With great respect, with great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना।
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है।
साहब यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए।
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Applications of your submission तो kindly देखिए।
मैं उसको ये इस तरह से आपको कहता हूँ कि आप ये balance आप रख
Attorney
लेंगे।
General Sahab, we are all grown ups, right?
Attorney General Sahab,
can I just the problem arose. I think thousands of articles have been written. Lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184(3) has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184(3), final judgment. Nothing can be done. Now we are concerned about full courts only. What about the three-member bench judgment? It was a three-member bench judgment which did Rekudik. It was not a full court or even a large bench. A three-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary. They'll say, what are you talking about? Independence of judiciary, independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought at the time, how they were assisted according to the conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है. हमने ऐसे ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को. मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया. फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. The minute I say that, please file a reference against me that I'm violating my oath of office if I say even this. Yeah, I will endorse these subsequent acts. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है. उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं. वो कहते हैं हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
One thing, my lord.
And
Section 6, my lord.
इसमें अटॉर्नी जनरल साहब लॉ रिफॉर्म्स ऑर्डिनेंस के तहत देयर इज अ राइट ऑफ अपील. लेकिन कई केसेस में डिपेंडिंग ऑन द इश्यूज द हाई कोर्ट्स कॉन्स्टिट्यूट लार्जर बेंचेस एंड देयरफॉर दैट राइट ऑफ अपील इज नॉट अवेल. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 इज डिस्क्रेशनरी. नाउ यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हुआ, इस एक्ट के तहत अवेलेबल नहीं. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में कि वैसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same. फैसला तो वही आएगा।
This was just
All
like,
judges
like,
from
like,
this
review,
court.
like review.
आपने conclude कर लिए?
My lord, I just now the, the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixing of cases, fixation of cases under
The
section
provision
7.
of intra-court appeal,
ये जो
that is to be seen.
आपने-
Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी?
My lord, at one end, now my lord would have to
देखिए
see
हम
how.
सारी बात चले ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं, इंटरेस्ट कर रहे हैं, उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? We the whole will be gutted.
How many cases would there be, my lord?
And no limitation period is
ये
here.
तो आप ना करें ना,
My lord,
ये थोड़ा
I
सा
think what has been
थोड़ा सा
what
इधर
we
ख्याल रखा
what
करें ना, आप रखिए, आप लाएं
what the parliament has,
चलो ठीक
my
है।
lord, what the parliament has tried to address here is
So you see, it
the
is very
same
open-ended.
principle.
Prior to the commencement of
Commencement
this act, so it will go to 1947 or
47
what?
जितने 185 73 से शुरू हो जाएंगे।
My lord, 1947 तो नहीं, 75 में पहला हुआ था,
एक बात है, अब इसमें
88
is
में आ गया
open-ended
था
ना.
दूसरा, and then
You have fixed a limitation of 30
subsection
days
2 of
for
section
filing
5.
appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद
law was
अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होंगी because the
Leonard-
law was
Suspended.
Leonard-
Okay, okay, I see.
Leonard
couldn't have
Attorney
taken
तो
effect.
फिर एक और
Leonard
वो एक और
Attorney General
छूट जाएगा ना।
ये बताइए जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है, कैन द पीपल ऑफ दिस कंट्री फाइल appeals and
Review.
have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And my
we
lord,
fear
just
if
to-
it's
just quick
Otherwise,
history,
we'll
I
be
think
brushing things under the mat.
1975 Manzoor Ilahi was the first case under 184(3), and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज्यादा जो jurisdiction exercise हुई है वो
And
perhaps
but where
पिछले
do you
15
draw the
साल में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. I
Let
mean,
it
why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court, Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Go on.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail में
ये
हमने
section
submission
6
करना
पे
है,
भी
वो
बता दीजिए
वाला.
Leonard Attorney General
My
की
lord.
जो आपका
Right to counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution,
उसमें order 26 है.
power of the review.
जी, order
So you
26.
have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा
Counsel.
my lord का 188 पढ़ लें जो refer कर रहे हैं. my lord.
188 is the Supreme Court shall
पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
Supreme Court practice and procedure.
In a situation where the whole full court is hearing it, the question of appeal does not arise.
My lord,
That's
ये अब
quite
15
simple.
बैठे हुए, so मैं just will say, so if it was in original proceedings, it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case, we are before your lordships in original jurisdiction, full court.
You know, इसमें ये जरूरी नहीं है कि one jumps from 5-member to full court. फर्ज करें अभी 15 जज हैं, ठीक है ना? फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9-member बेंच बन जाता है. फुल कोर्ट तो नहीं है.
My lords would be
नहीं,
mindful of
बात
this.
सुनो.
Committee
अब
would
ये
be
हो
mindful
सकता है,
of this.
हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब, फर्ज करें 3 मेंबर कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 मेंबर बेंच बना देते हैं।
My lord,
आप देखिए ना, आप इसको एड्रेस कीजिए ना, ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया। आप ये
मैं what I'm submitting is that now it's a duty cast हो गई है इस कमेटी के ऊपर।
अपील
पर उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना, नाउ यू पुटिंग द ड्यूटी ऑन द फुल कोर्ट, तो कोर्ट तो फिर अपनी मर्जी पर ही चल रही है ना, व्हेनेवर इट वांट्स टू डू समथिंग और राइट ब्लॉक करना चाहेगी। व्हाट यू आर सेइंग इज दैट सब्सटेंटिव राइट दैट यू हैव क्रिएटेड अंडर द स्टैट्यूट is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं। तो फिर आपने ये right दी किस मकसद के लिए?
8 member bench बन जाए, 9 member bench बन जाए, right of appeal खत्म हो गया।
So let me just
I think what we can do is we
logically
can logically interpret the legislation. Now, for instance, when this case was first being heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई।
Actually जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी, उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं full court बनाई जाए, आपको तो कहना ही नहीं चाहिए कि full court बनाई जाए, आपको तो कहना चाहिए this matter should be heard by lesser number. वो CMAs क्योंकि वो hearing पे नहीं गई,
but the burden at the end of the day was on us.
Question was in fact put by me, and so therefore it's not that the question was not there.
Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस तो ये हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8-member बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं, अगर हम बेंच पे एतराज करें इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 member बन सकते, व्हाई नॉट फुल कोर्ट?
So मैं इसका brief एक response दूं and then followed by a detailed response in writing. Briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench,
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
in cases, in circumstances में ये हो सकता है, जैसे अभी भी है।
Repercussions तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से।
So let me put it differently.
Now full court कभी बैठ ही नहीं सकती।
नहीं, full court आप बैठेंगे।
Article 184
exceptional matters,
questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that enough to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. So there is no, I mean, doesn't really, it can be easily
It can be reconciled.
Can
My
be
lord,
read
section
down.
6, right to appoint.
Section 5 can be read down.
My lord, to that extent, my lords can hold that in exceptional cases and when a situation of this sort arises, that be so.
Right of appeal पे substantive right नहीं है जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not, and all of that has happened under 184.3. With great respect, with great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? How many of those were full court judgments?
My lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए.
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी
नहीं, there might be issues in time.
Applications of your submission तो kindly देखिए.
मैं उसको ये इस तरह से आपको कहता हूँ कि
Attorney General साहब, let's be, we are all grown ups, right?
Attorney General साहब,
can I just the problem arose. I think thousands of articles have been written. Lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are concerned about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did recodic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and place it at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about? Independence of judiciary, independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought at the time, how they were assisted according to their conscience, correctly. Their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record. So they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस लेजिस्लेशन की भी जरूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा प्रॉब्लम ये हो गया ना, अन्ना बहुत बड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई, मान लें गलतियां हुई हैं. ठीक है, हमने ऐसी ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है. ठीक है, अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. The minute I say that, please file a reference against me that I'm violating my oath of office if I say even this. Yeah, I will endorse these subsequent acts. मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिगर पड़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं, वो कहते हैं हमारा केस चला के खत्म कर लें. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets its due. But what are we doing? What are we taking away from him? Focus on that.
Nothing, my lord.
And
Section 6, my lord.
इसमें अटॉर्नी जनरल साहब लॉ रिफॉर्म्स ऑर्डिनेंस के तहत there's a right of appeal, लेकिन कई केसेस में depending on the issues the high courts constitute larger benches and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना जो अभी बात हुई है 184(3) is discretionary. Now यहाँ पे जितनी बात हुई है even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो इस एक्ट के तहत अवेलेबल नहीं है. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily as judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the constitution.
The remaining judges would be the same. फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए. My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section 7.
Provision of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have to see
देखिए हम सारी बात चले ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं उधर आप उसको रिट्रोस्पेक्टिव. अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप. व्हाट डू यू एक्सपेक्ट अस टू डू देन? We the whole will be gutted.
How many cases would there be, my lord?
And no limitation period is here.
ये तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been
what the parliament has,
my lord, what the parliament has tried to address here is.
So you see, it is very open-ended. Prior to the commencement of this act, so it will go to 1947 or what?
जितने 185 73 से शुरू हो जाएंगे.
My lord, 1947 तो नहीं, 75 में पहला हुआ था.
एक बात है, इसमें there is open-ended ना.
And then
You have fixed a limitation of 30 days for filing appeal prior to commencement of this act. Means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद अपील कितनी फाइल हुई है इस प्रोविजन के तहत.
वैसे नहीं हुई होगी because the law was
सस्पेंडेड.
Okay,
I see.
it couldn't have taken effect.
फिर एक और छूट जाएगा ना.
ये बताइए जितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है, can the people of this country file appeals and have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why do
And my
we
lord,
fear
just
if
to-
it's
quick
Otherwise,
history,
we'll
I
be
think
brushing things under the mat.
1975 Manzoor Alai was the first case under 184.3, and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw the
साल में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. I
Let
mean,
it
why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court, Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because everybody's dead or whatever, long past. Go on.
My lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail में
ये
हमने
सेक्शन
submission
6
करना
पे
है,
भी
वो-
बता दीजिए लर्नेड अटॉर्नी जनरल,
My
ये
lord.
जो आपका
Right
राइट
to counsel.
yes, because it
Now-
is already covered under Article 188 of the Constitution,
उसमें order 26 है.
power of the review.
जी, order
So you
26.
have said that the party shall have the right to appoint counsel of its own choice.
पहले जरा
Counsel.
my lord का 188 पढ़ लें जो refer कर रहे हैं my lord.
188 is the Supreme Court shall
हाँ, पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review
Bismillahirrahmanirrahim.
order 33 itself
वो तो खुद ही देता है.
I
वो
think
खुद
the
कह रहा है
constitution
कि
actually
abuse of
mandates.
process नहीं होगी and of justice को meet करने के लिए आप you're not bound by
Attorney
the
General,
that
the
extent.
rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them.
And
they might be in the trajectory starting with the Constitution, law, and the rules, but all of them are binding,
And-
and that's how the system
and
works.
and my lords would also